Recourse, a program that tackles issues affecting your rights and matters of legal recourse. My name is Dumila Matez. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. You can also SMS your views by sending the word recourse to 34025. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. South African workers seeking recourse against their employers are celebrating another gain. New amendments to the Labour Relations Act now promise to further strengthen the protection of workers' rights against employers who fail to comply with legislation. Now, the Commission for Conciliation, Mediation and Arbitration, the CCMA, has been given more powers to act against transgressors. Before we examine the effects of these changes to the labour relations landscape, let us take a look at this insert.
Many workers, particularly the low-income workers, turn to the CCMA for intervention when they are being subjected to unfair labour practices by their employers. Why do people go to the CCMA?
I've been left out of pocket yet again. As a freelancer, this happens quite often, and I'm afraid this time I'm doing something about it. I've actually got to the stage where enough's enough. That's why I'm here.
Once a successful ruling has been granted by the CCMA in favour of the worker, they still have to turn to the Labour Court to enforce the ruling at the expense of the worker. The new Basic Conditions of Employment Act will offer some comfort to workers, as they will no longer need to turn to the Labour Court to enforce a successful judgment granted by the CCMA. Can it work?
If they implement it correctly, then it will be positive. Is that so then it'll lower the costs of instead of applying to the Labour Court and then paying costs and then only recovering it 6 months later when the employer eventually complies with the court ruling.
Unions have welcomed the provisions in the new act which seek to protect the vulnerable workers, but warned that they will closely monitor the implementation of these clauses to ensure that they are properly enforced.
The workers who are not permanent, who are under labour brokers, they must work not more than 3 months. If it's more than 3 months, they must get or be treated like permanent employees. CCMA has also been empowered to have a situation where the worker has been dismissed. If the employer appeals to the Labour Court, which as we speak it takes long, now CCMA can intervene, the CCMA not to wait for the Labour Court. And also, if the worker has been dismissed, the employer has got an obligation to guarantee the majority of them are good for the workers.
There's now a new law that the employer will have to basically put down a deposit. They'll have to make a financial, what's called a security, which we hope will stop frivolous review applications. That if the employer genuinely thinks they've got a good case, then they've got to put their money where their mouth is. Now, well, they have to do that. They can't simply put things on review purely in order to buy time. And so that's a very good example of where something which was never intended to happen did start happening, and we hope now will stop.
What's the feeling of the ordinary citizens?
I'm happy with the new amendments because the CCMA is going to help people like us.
The Department of Labour and the CCMA will tomorrow embark on the roadshows in various provinces to promote and educate citizens about the new changes. Malima Digwa for Rights and Recourse.
Well, being up there from Bali to discuss this and many other issues around the Labour Relations Act amendment is Mr. Cameron Murajane, National Senior Commissioner from the CCMA Legal Services Department, Professor Paul Benjamin, Director of Chittle, Thompson and Hazen, Attorney, and Andrew Goldberg, a labour lawyer from Goldberg Attorneys General. Good afternoon and welcome to Rights and Recourse.
Good afternoon.
Thank you very much.
So let me start with you, Mr. Murajane. What impact are the new amendments going to have on the Labour Relations Act, especially in terms of the CCMA?
Well, the impact is going to be quite huge. I think the best way to explain it is that when we're talking about the changes to the employment law, it's not just in terms of the Labour Relations Act. It is the Labour Relations Act, it is the Employment Equity Act, and also the Basic Conditions of Employment Act. And each and every one makes provision for different things. Now, listening from the inset, I can just take off, maybe give a good example of the type of impact that it's going to have. In particular, the one that deals with the enforcement of the awards. What is important to understand as well is that the legislature or the lawmakers in the normal course, they would not change a law unless there's a reason, or what we call a mischief in terms of law, something that is wrong that is happening they're trying to cure. The problems that are associated with awards that we issue, I'm sure you will accept that if an employee has an award in his favor and he wants to execute that award, but they are unable to execute them for a variety of reasons. Part of those reasons are the following. One, maybe it's because it is being reviewed. Number two, it is the expenses occasioned that when it has to be sent to the Labour Court for the registrar to put the stamp before it goes to the sheriff. And thirdly, it is the indigent or those that are quite poor or the vulnerable employees that are unable to afford sheriff costs and to afford attorneys to be able to assist them to do so. An important change in relation to what we call Section 143, which is the enforcement of the awards, is quite significant, and I'll explain why that is important. Number one, the significant change is that once an award has been authenticated by the CCMA, before the amendments, an employee was expected to come to the CCMA, fill in the form, we certify it. The next step, it goes to the Labour Court and have the registrar put the stamp, and then from there it goes to the sheriff. Gets to the sheriff, when he has to execute, he asks for security. That look, security for cost, my cost, and damage to property that I'll be taking in case that is necessary. So that has been about to a proper execution on a properly executed award. The amendments do away with those kinds of issues. In particular, the one that deals with the requirement to go to the Labour Court. Once we have authenticated an award, an employee can go straight to the sheriff and execute that award without a specific requirement to go to the sheriff. In addition to that, and I must emphasize this part, in partnership with the Department of Labour, we have established a mechanism which will assist vulnerable employees to execute when taking their awards taken to the sheriff. There's an amount set aside which is administered by both the CCMA and the Department of Labour, which amongst other things deals with those kinds of costs. In other words, if an employee goes to the sheriff and the sheriff says, look, I'm looking for my cost and this is the amount I need, so we'll step in and give guarantee of those costs so that the execution can proceed. That is one typical example which is very good in my view.
In other words, are you also saying the sheriff can wait until the award has been made, has been executed, and then get his money paid, believing that he might get paid? Can we work on that basis too?
What is important is to understand the steps. Once I have the piece of paper called the award, the employee goes to the sheriff and says, Sheriff, this employer owes me money. It is important to also explain that normally the award will also have two parts. It will have the money portion. It will also have the specific performance, which is like re-employment or reinstatement. So the sheriff cannot help with the re-employment or reinstatement portion. That is the portion that is dealt with by the Labour Court. So in other words, he goes there to just get the money portion. The money portion, he goes there. If the sheriff asks for cost, we then give security for that. He goes, attaches, and then he sells. Then he gets his money. Then that problem is resolved. So the employees are not frustrated like those that you see in the inset. If the employee feels that the employer is not complying with the award in as far as the reinstatement or re-employment portion is concerned, unfortunately that portion, he has to make an application to the Labour Court for contempt proceedings. In other words, the employer is in contempt of an award. Therefore, he asks the Labour Court to assist in ensuring that he is reinstated. If the employer does not do that, then he's in contempt, and we know that is punishable by way of imprisonment or fine.
Well, I've got two lawyers here who have been listening very intently to what you are saying. We actually have gone through the Act and understand the things that are done. Is it that easy? Is it going to be that easy for these awards to be executed?
I think we should put these changes in their full context. The CCMA has been one of the great successes of post-apartheid South Africa. Institutions that's been created that has allowed workers to take cases at no cost, and those cases are resolved much quicker than in the in the court, a dismissal or arbitration generally is resolved within 3 months. A problem has developed that thereafter many employers either obstruct the implementation of that award, or just wait, and it's difficult for workers who've often been unemployed for some time to have the cash to go to the deputy sheriff and have the award enforced. Certainly what these amendments seek to do in very important ways is to streamline that second process, to allow the process through the labour court to be much quicker, and as Cameron has indicated, in situations where workers don't actually have the money to cover the initial cost of the deputy sheriff, those will be covered by the CCMA and the labour court, which will mean that the fact that the employee may no longer have any money will not prevent him trying to enforce his award. As we know, in practice, once the deputy sheriff arrives, either at an individual's house or at a business, people take the law much more seriously. They know that there's a real prospect, if they don't comply with that award, of goods being sold off. So it's very important that those cases get to the deputy sheriff as quickly as possible. And I think there's, as Cameron has indicated, a lot of important work done by the Department of Labour, the changes to the LRA that came through NEDLAC, and the CCMA that are going to see that process speeded up, and people who have adopted the view that they can disregard awards are going to find that that's no longer going to be the case.
Well, I'm actually intrigued by one thing here, Andrew, and that is the issue of the CCMA will actually force that these awards be implemented or executed. But many people believe if I want something to be implemented or an order to be implemented, the order must come from a court. It must be signed by a judge. So if that's an order, you do that. The CCMA is not a judge. It's not a court of law.
Definitely not. But the thing about the CCMA is that the award is final. The making of the award and the award is final. Once you get the award, then you take that to the sheriff. And as we were saying earlier on, the important part is that there's 2 parts to the award. There's the reinstatement part or the re-employment part, and that can be sorted out through contempt of court proceedings. And contempt of court proceedings have also been streamlined. There's an ex parte application which is brought. It's streamlined, it's got an exact procedure of how to bring it at the labour court. And once that process is on the go, it's very easy to get through that.
Cameron, the one thing that I needed to find out here, many people tend to say, I say the same thing, when I see the queues of the CCMA, or people going to the CCMA, that indicates the strength of your economy. What kind of cases are brought to the CCMA these days?
It's all kinds of cases. Just to give an example, the amendment to the Employment Equity Act came into effect on the 1st of August 2014. And to date, we've received more than 1,200 cases in relation to the portion that relates to that amended provision. But what is not understood properly is that the old cases before the amendment, the way they used to be referred, it continues, it's business as usual. But what has happened, the number of cases that we get have now doubled because of the new provisions that have been made. To give an example again, there's another amendment in terms of section 115 that says the CCMA is expected to provide admin support to employees who are below the threshold as set out by the Basic Conditions of Employment Act, which is 205,000 rand. So which means as the CCMA, given those queues that you're referring to, because of the referral rate that has increased, we apply more resources, not because it is the statutory requirement, because that we normally did, but because of that, we have now employed more resources to be able to deal with that backlog. But the kind of cases we get, it's unfair dismissals, which is the highest, more than almost 80%, about 75 to 78% of unfair dismissals.
Let's hold it just there.
Okay.
We'll come back. That's our first point. We're going to talk about unfair dismissals. If you'd like to join us in today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse, or email us at rightsrecourse@sabc.co.za. We'll be back after the break.
Places some are afraid to go. Discussions some are afraid to have.
Leave the house. We're not going to say anything further than this.
But some have the courage to open their eyes, to go to those places, have those discussions.
You're pulling at least 18 hours a day?
Because sometimes perceptions need to be altered.
It's been dubbed the trial of the century.
And when you get to a press conference,
they were hoping that that would stem the tide.
Stories need to be told in a language everyone can understand.
Once you have religious power, you can abuse people.
But they have got benefits. Free marijuana.
I can only hope that you media, you hear these things.
Everything you might have been afraid to ask, but need to know. SABC Current Affairs.
Welcome back. Let me come to what we were speaking about earlier. Yeah. What constitutes an unfair dismissal?
What constitutes
an unfair dismissal?
Well, it varies. Let me put it this way. There are different parts to it. And depending on the evidence, there's two main legs of finding whether a dismissal is fair or unfair. It's either the way that the employer has followed, which we call procedural fairness, is wrong, or the substance, meaning the reason for the dismissal. So in the evaluation of that, you then determine overall whether the conduct of the employee warrants a dismissal, and that's the test for fairness that we put. So in the substance, you will have, things like whether there was a rule infringed and whether the rule is reasonable, and all those it's listed in the Act. So when the commissioner sits and evaluates based on the evidence of both parties, then he evaluates whether it complies with that, whether the decision of the employer is fair. He's not reviewing the decision, he's testing whether that decision that was taken by the employer, whether it's fair or not. And secondly, test whether the method, in other words, the procedure. In the normal course, you find that when an employee commits or violates the rules of the company, then there's a disciplinary hearing that is instituted generally, which is not really encouraged, to try not to turn workplaces into courtrooms. Because the requirement of the Act is that the employer must investigate the evaluation, give the employer an opportunity to respond, let him be represented, give him a written outcome. If he's not happy with that, then he refers that to the CCMA, it comes to us. Then when they come to us, if it's called unfair dismissal, we test both. Is it substantively fair? Is it procedurally fair? Have you followed the right process?
Probably, in order for this question to be answered properly, you can take part, gentlemen, in this discussion. The question should be, I have seen employers inserting into contracts, fixed-term contracts and freelance contracts or part-time workers contracts, saying this contract is not, there's a clause that says this contract does not indicate that we might employ you full-time in future. But the person works for 5, 6 years, 10 years as a part-time employee, and that cannot be right, surely.
Well, that's one of the areas where there's been a significant change in the law. It's correct that in many sectors of the economy there's been widespread abuse of fixed-term contracts. Fixed-term contracts are in a sense rolled over. Workers are always on a 1 or 2 year contract. What the law now says is that you can initially hire people on a fixed-term contract of 3 months. Outside that initial 3-month period, you need to have a justification for a fixed term. So there must be a reason, for instance, that one of the reasons is that the employment may be subject to external funding, or you may be employed on a project that's going to end. But absent that type of circumstance, an employee will be considered to be in indefinite employment.
Let me get you clear, Paul, here. You are saying employers have a tendency of engaging people for 3 months, and then after 3 months roll over that contract, restart the contract after every 3 months, so that he's not told, no, this employee has been here for 20 years, and every 3 months you've been rolling over this contract.
No, but the law as it's changed will prevent that practice, because assuming the contract expires on the 1st of January 2018, and the employer says, the reason I'm not keeping you on for next year is because you had a fixed term contract, that won't be good enough any longer. The employer will have to show that a fixed term contract was in fact concluded for a justifiable reason. If the employer can't do that, that employee would have been in indefinite employment, and the employer would have to show a reason for the dismissal. So that's been perhaps one of the most significant changes to our law, and that's an attempt to address this practice of rolling over fixed-term contracts.
Andrew, these are the kinds of things that come to your office, where people come to your office to come and say, I've been treated unfairly, I've been there for 15 years or 5 years, and now I'm told there's no work for me.
But the point of the Labour Relations Act is that you must try and get the person back at the job. I mean, we're trying to, in the Labour Relations Act, is always try to get people reinstated in their position. The law can't be taken to the hands by the employer. The employee must be treated fairly. And that comes to the next point, is that the new Labour Relations Act makes all employees that do the same job get paid the same amount of salary.
We'll get to that. We'll get to equal pay. I just want to go back to these 3 contracts that I've mentioned. One is a fixed-term contract. The other one is a freelance or a part-time contract. And then do you have another one? There are these contracts that people are normally getting. And after every 3 months, these contracts are renewed, so that to circumvent a requirement that says, if I'm working more than 3 months, I'm working 14 hours a day, 40 hours a week, 8 hours a day, then I'm supposed to be a full-time employee. It means you need me here every day.
Let me explain that portion. Firstly, in law, there's nothing wrong in fixing a contract, because that's a freedom to contract that the parties must exercise and enjoy. What is wrong is the abuse that is associated with it, which in its application, then it takes away certain benefits that employees should enjoy as employees. One of the ways of avoiding that is calling persons independent contractors. What that concept means...
Yes, not the other contractor I was looking for, the independent contractor.
Yes, what that effectively means is that on the face of it, the contract says, I am not an employee of this company. You are an independent contractor. You'll use your own resources at your own time. What I am particularly interested is for you to give me this outcome or this type of a product, right? So effectively, you are denied, like your pension fund and all those things relating to that. And you, strictly speaking, should not even be dismissed because you're not an employee. But the problem comes in situations where, in fact, the person's operation at work at that particular workplace, he is in fact an employee, but the contract says differently. So that is trying to avoid the application of the law, especially the employment law. So what then ordinarily happens, it doesn't really matter what you call the contract when it comes to the CCMA. What matters is what is put before the commissioner to test. How many days do you spend there? Whose resources are you using? Are you under somebody's control? Are you subject to discipline? Do you have UIF? All that list is taken into account by the commissioner to make a determination whether you're an independent contractor or you are an employee. And in a normal course, you find that when a person has been dismissed, because that's when they realize that actually I am an employee, and then comes to the commission, then we make a determination. So one of the determinations that the commissioner must make is whether this person is an independent contractor or is an employee. If it's an employee, is he on a fixed term? If it's fixed for how long? And what's the reason for a fixing? Does he understand those terminologies? That is the reason why, in terms of the current amendments, when the legislature legislates, is trying to deal with that part of a problem. Of course, you don't ignore the fact that the contract is called a fixed term. It's a factor you take into account, but it's not the dominant issue that decides whether a person is an employee. But strictly speaking, there are cases where a person is truly an independent contractor. They want to be independent. They've got more than one contract they work on. They render service to a wide range of people. They don't want to be limited to one institution. But there are those who are exactly the opposite, who want to be employed, enjoy the benefits, but they don't enjoy that because they're called an independent contractor. So that's where we come in to make a determination and interpret on who is an independent contractor and who is an employee, because it has a bearing on our decision.
Paul, how will all of these things, seemingly, they are a little bit unfair to the employee. Some of them are indigent. To them to be given these kind of contracts without them being educated around these issues. How did these things, why were these things allowed to carry on for the last 20 or so years?
Well, if we look at the issue of independent contracting, that is an international issue, but it emerged particularly in South Africa in the late 1980s, where employers were advised call your workers independent contractors. The law has responded to that, and it's no longer good enough to do that. As Cameron indicated, the test is, how does the employee actually work? Are they supervised? Are they controlled? Is the person genuinely independent? And our law in that regard on paper is certainly very, very good. With regard to, is it unfair to employees? The employment relationship obviously operates in a very unequal context. Workers are desperate for employment. Many employers do abuse the power that comes in the employment marketplace. The CCMA, other organizations, programs like this are intended to assist workers by spreading that knowledge. And certainly one would certainly say that in respect of certainly the issue of independent employment, our law and practice is very much better than it was 20, 30 years ago. There's a separate issue that you raised, and perhaps we should just separate that. That's the issue of part-time employment.
Part-time employment.
There is nothing to stop people having part-time employees. Again, so the law doesn't stop, as Cameron indicated, the law doesn't stop fixed-term contracting. It doesn't stop part-time employees, but it seeks to deal with the abuses associated with part-time employment. Now, one of the abuses often associated with part-time employment is that you have people who work in almost a ghetto where they are employed 16, 20 hours a week, and they never get a chance to move into full-time employment, even though they may be people who want that. They haven't voluntarily opted for part-time employment. What the law now says, for instance, is that when an employer is filling vacancies for full-time jobs, part-time employees must be given the opportunity to apply for those.
Now that you talk that if an employee is filling up a job for somebody who's off sick, or it happens with people who go on maternity, they normally get somebody to come in the place of the person who goes on a maternity. How should that be interpreted in terms of, I've been here, probably I'm here for more than 3 months, because the person has to take 3 months leave before she or he comes back. You can take it, Andrew.
Yeah. Okay. Well, the point of the matter is that the person who's gone on maternity leave must keep their job. You've got to keep their job open. You cannot replace somebody who's on maternity leave. But what you can do is get somebody on a temporary basis to work in their place and do their work. And then when they come back, obviously they then fill in. And that person, then you have to find another job, or then you have to retrench them, or you have to say to them that was part-time.
Now the 4 months, the 3 months don't come into effect there. No, I've been here for 3 months. Now, probably in this 3 months, you should have been thinking, can I find something else to do for this person in case the other one comes back?
No, in terms of the amendment, there's a specific exclusion of that category, because you are specifically brought to do just that, to stand in for somebody who's on sabbatical leave or somebody who's on maternity leave, and you serve that purpose. It will be unreasonable to expect that you would want to be employed on that position or to be kept on a permanent basis because you were filling in a position for somebody else. So in terms of the amendment, there is a specific exclusion for persons on sabbatical or somebody who's staying in terms of maternity, in terms of Section 98. So that is covered.
Well, we're going to go on to this discussion. Seems to be a riveting discussion around this issue. I want to just touch on a few other things before we move on around this very issue. If you'd like to join us today's discussion, please call us on 011 714 5497. We'll be back after the break.
Four-month-long strike at the post office is officially over for now.
Workers have indicated to us that we must proceed with a dispute, and we must lead them in the next industrial strike if it comes to that particular point. They felt betrayed by the intervention of our government through the minister, because that intervention simply backstep workers.
A sophisticated network of illegal cigarette smugglers spread out across southern Africa. And many of the dodgy smokes land up here in South Africa. Is it this simple that you know that you're probably smoking an illegal cigarette if it's ridiculously cheap?
It starts with consumers. So if you buy cheap cigarettes, you're not buying a bargain. That's Business News, weekdays at 6 p.m. on SABC News.
Welcome back to our discussion on the Labour Relations Amendment Act. The one question I wanted to find out, Cameron, is there an obligation on employees to renew, the question is there an obligation on employers to renew a fixed term contract?
Not an obligation as such. This is how it works. Normally you find in contracts that you'll find a clause that you shall not have an expectation that this contract will be further renewed. That's a general term we find in fixed term contracts. But before the amendments, there was this provision that an employee who works on a fixed term contract, sometimes it depends on the conduct of the employer as well, that if an employee, for example, works for 6 months, and then they renew it again for 6 months on same terms and all of that. So in the third time, when there has to be a third renewal, the employer says, no, I can't do that. Then an employee in terms of Section 186 then refers a dispute to the CCMA saying, look, they have not renewed my contract, or they've renewed it but on lesser terms. So that constitutes a dismissal. Correct, in terms of the Act, it does constitute that. But what is key is what we call a reasonable expectation, right? An employee, whether at the time, had a reasonable expectation that his contract will be renewed on similar terms. And if that not is done, then it constitutes a dismissal. So that's what happened. But the expectation is not an expectation for a permanent employment. Is an expectation that it shall be renewed on same terms. It's going to be fixed. So before the amendment, the law was clear that you cannot have an expectation of a permanent employment if you're on a fixed term contract. That has changed now. That an employee, depending what happens during the course of employment, you can have an expectation that you can be employed on an indefinite contract if there has been representation or conduct during the course or promise made that you'll be employed for that period. So in as far as the expectation is concerned, how far we go is to deal not what really what the employer expected. It is whether the employee at the time the contract is not renewed had a reasonable expectation based on the conduct of employer that it will in fact be renewed for the similar terms or on an indefinite period, depending on the matter.
While Cameron, the producer or the director, will cut my head, he said earlier I must go to the tweets. Let's see what the Twitter community is saying on this matter, on these very issues we are discussing here today. Hardly see. My mom was sick for the whole month, and they called their lawyer to terminate her contract. That is Ivan Lovo. Zanele Shongwe says, so as I can see, some of us are afraid of going to the CCMA to lay a charge against our companies, bosses, because they always without I can't see that.
Without knowing.
They don't always win without knowing. And then Mhlongo says, Lady Mhlongo says, how long can one work as a freelancer for a company before you can get permanently employed? Majola says, no, in fact, it is dangerous to keep on renewing a fixed term contract. I don't know, any of you can take some of those that were raised. The pertinent one for me is a mother who was sick and a lawyer was sent a lawyer's letter, she's been fired.
Look, yeah, clearly we cannot make a determination whether that's fair or not, because the other side has a story to tell as well. But on the principles, it is simple. Any termination of contract must pass the test of fairness. And to pass the test of fairness, number one, has the contract in fact been terminated? If that threshold question isn't answered, then we go to the next stage. Was it done fairly? And fair means, did you follow the correct procedure? Is the reason for termination or dismissal correct? It could be operational requirement, it could be misconduct, it could be any of those reasons that are stated in law. So that's what we test. Then upon receipt of what the employer says, because I'm sure that the employer has something to say to it, and what the employee says, the commissioner sits and evaluates the evidence presented. Then you make a determination. So to send a letter of termination, because sometimes people tend to mix the difference between a fair dismissal and a lawful dismissal. There's a difference there. A lawful dismissal, you can say in terms of the contract, I give you notice, so it's terminated, it's finished. Lawful, you can say that's correct. But fairness is a different test. It depends on procedure, it depends on substance, which are reasons. So it will be difficult to answer whether that is correct or not. But that's the process that needs to be. All she needs to do is to refer this dispute within 30 days to the CCMA and say, there's a lawyer who terminated my services and I was not even, I don't understand what's going on. Then of course our commissioners will be there to assist and then listen to the story, and the employer will be called as well to give his version.
Paul, you wanted to add something?
Yes, there's one exception, that if you work for the government and you haven't been there for 30 days, then you're terminated by operation of the law. That's not a dismissal.
That's right, you terminate by operation of the law because there's
and
nobody else to do your job.
You'd have to appeal that. So as soon as 30 days are up, or a month is up, once you work for the government as a teacher or the like, you cannot be away from your work for 30 days, because then the law steps in and says your termination, your employment is terminated by the law.
Thank you for that one. That's a very good one. Paul, the one thing I wanted to bring to you, can an employer change the conditions of a contract or employment without consultation with the person who signed the contract?
Well, let's just resolve the issue of sickness. I think it's important. There's one of the grounds for dismissal is what is called incapacity. Incapacity can either take the form of not being healthy, not being able to do the job for health reasons, or not having the capability to do the job. It's a complex issue. At what point does someone being sick mean that you can no longer do the job? And there, as Cameron indicated, each case is different. Has the person sent in medical certificates, that type of thing. But ultimately, quite a significant proportion of the cases before the CCMA do involve cases about sickness and whether the employer is entitled to replace in those circumstances. To get back to changes in terms and conditions of employment, remember, a contract of employment is a contract like any other contract. Contracts are bilateral. They have to be agreed upon. And therefore, employers can't unilaterally change conditions to make them more adverse for employees. So you have to get agreement on contracts of employment, and where employers want to, for instance, change issues such as shift systems, which is a common issue in our law, and workers don't want to agree to, for instance, moving from day shifts to night shifts or continuous shifts, then they become complex issues where employers often have to argue that they have operational requirements.
Let me just, I'll come back to this issue because I want to pursue this issue further. I just want to take this call from Gauteng. Good afternoon and welcome to Rights and Recourse.
Yes, sir. How are you?
Fine, thanks. How are you?
I'm fine. I have a situation. Can you hear me?
Yes, we can hear you.
Yes, I have been working for a company for 2 years now, and then on 6 months contract. So now there is a possibility that in fact we've been advised to apply the very same positions that we've been occupying for 2 years. So I just want to ask the panel there to say, is it advisable for us, for me to apply, or should I maybe take certain rules? I'm not sure.
Thank you very much. I did not get your name there earlier before we started.
The name is
Tisco. All right, Tisco. That's a case that is happening all over, where people are in positions, have been doing the jobs, and probably doing their jobs very well, depending on what the operational procedures are around the job. But then they are told, you've got to apply for the job you are sitting in. Is that fair?
In general terms, the best advice to someone like that is that they should apply for the job, but do so under protest. In other words, apply for the job, but say, I don't believe I am required to apply for it because it is in fact my job. If people take, in a sense, an issue of principle to say, I'm not going to apply for the job, they may then find themselves in the difficult position of losing their jobs and then being drawn into lengthy litigation. So people in that situation should get advice either from a union or colleagues, and generally it is advisable to apply, but to, in a sense, reserve their rights and indicate that they believe that they're entitled to the job in any event.
Cameron, the one question that I wanted to talk about is, what is the difference, or I've asked these questions before, the difference between all of those contracts we talk about, but what I want to, can a fixed term contract workers be treated less favorably than the permanent employees?
In terms of the amendments currently, especially employees who earn below the threshold of 205,403.30 cents, employees should not be treated differently. They should be treated the same or similar, especially those who are doing the same or similar work. They should not be treated differently. That's the provision that is made in terms of the amendment currently. And also sometimes it depends on the type of contracts we're talking about. If you are an employee who is, for example, working as a substitute for someone on maternity leave, that's a different issue because yours is excluded specifically with regards to that. But employees should be treated the same or similar to employees comparable in the same position.
But surely there are cases in employment where you are saying these benefits are for full-time employees, like housing allowance, medical aid, pension and pension fund and all of those things. But where do you draw the line? Where, for instance, a person who's on a fixed-term contract, that person surely should get some of those benefits.
That's exactly what it meant by the equal treatment for employees. For example, someone on a fixed term is not automatically meaning 3 months. It could be a fixed term for a period of 5 years because that's still a fixed term contract, and it will be quite, it will be unfair for a person on such a fixed term contract to be treated differently comparable to the employee who's holding a similar or same position. So the amendment dealt with that specific portion, say that employees on fixed term contract should not be treated less favorably to employees comparable or employees who are holding a similar or same position. So that is the change that has been brought in terms of Section 198 currently.
The aspect of labor brokers, I know you wanted to say, the aspect of labor brokers, I know the unions have been going on about the labor brokers and that is still bubbling along. And apparently I see there's an amendment that says in the past, if you are employed through a labor broker, your employer is a labor broker. It doesn't matter what happens to you in the workplace. And on top of that, now the amendment has actually changed that. Is that true?
Correctly. That's what we call a temporary employment service in terms of Section 198.
Just hold that thought. Let's take this call because she was on and she dropped. Sidi from Gauteng. Sidi, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir. I just want to find out that before you take your employer to the CCMA, is it procedural to appeal? Do you have to appeal first with your employer, or you can just take?
You mean appeal internally?
In-house.
Sorry?
You mean appeal internally?
Yes, appeal internally before you go to CCMA, or you can just take your employer directly to CCMA after a dismissal. That's my question.
Well, the answer to that is really, it depends on what the employer's procedures are. If the employer's procedures provide for an internal appeal to some sort of appeal body or a more senior official, then you must do that, and it may be held against you. If, however, it's a small company with no formal processes, as soon as you've been dismissed, you can go directly to the CCMA.
It has happened in the past, but I think you were answering the question, but we'll come back to that question.
Yes.
I've been directed to go to a break because we have to sell some of the food to make money to be seated here. If you'd like to join us, please do so and call us on 011 714 5497 or 5498 or tweet us at Rights Recourse. I'll be back after the break.
Type 1 diabetes happens when your pancreas stops working, so the body does not get insulin anymore.
I have diabetes. My life is changed. I was in a total state.
Too much food, too little exercise. That's what it's about.
Hot flushes. So you would start with lifestyle modification, wearing cotton clothing, eating right, etc. And then hormone treatment for hot flushes.
Join me on Health Talk every Saturday morning between 9 a.m. and 10 a.m. as we unpack current health stories.
Welcome back to Rights and Recourse as we tackle the issues of the Labour Relations Amendment Act that were promulgated late last year in August, in fact, to be exact. And let us go back to Dolly, who's calling us from Gauteng. Dolly, good afternoon.
Good afternoon, sir.
What's your question?
Yes, I just wanted to ask, I've been with this company for 4 years under labour brokers, ne?
Yes.
And then by September last year, our contract was for a year. Always we were doing it for a year. Then last year by September they changed it to 6 months, which was supposed to end on February the 1st. That's 6 months.
Thank you, Dolly. We'll try and answer that question. Cameron, quickly. Contracts are coming to an end in March. You'll have an avalanche of people coming to the CCMA with these kind of questions. Yes. You were answering this question with the labour brokers. Could you elaborate?
Yes, I want to just put it crisply and in the step form for it to be understood properly. There is a difference between a temporary employment service and a temporary service. A temporary employment service, it is an institution that deploys employees to work for the client. That's what is commonly called a labour broker. They are broking using the employees. So currently as matters stand, is that if an employee earns below 205,000, like I said, right? That's the first requirement. The second issue, the employee is deployed by a temporary employment service to a client, right? Such employees, when they are deployed there and they work for more than 3 months, the interpretation we have as the CCMA currently is that after 3 months, an employee becomes an employee of the client, no longer an employee of the temporary employment service. But up to 3 months, you are still an employee of the labour broker. Whatever happens, you do with the labour broker. But once you cross that bridge of 3 months, then you become an employee of the client. Interestingly, what I must mention, which is very important, which is going to cause a lot of influx of cases to the CCMA, is this new form of dismissal that is created as a result of that provision, which says if a labour broker terminates the contract or whatever action that it does to avoid the deeming provision from applying. The deeming provision means after 3 months that the person becomes an employee of the client and they remove you. If the intention is to avoid the deeming provision from application, that is a new form of dismissal which must be referred to the CCMA in terms of section 198D, wherein an employee will say that at the time when I was on the verge of becoming an employee of the client, then I was removed.
Let's take this call from Pumala, from Makata. See, Makata, so we did not read his tweet, now he's calling. Makata, good afternoon and welcome to Rights and Recourse.
Yes, good afternoon, sir, and good afternoon also to the panel.
Good afternoon.
Afternoon.
Hello. Yes, I just have 2 questions for the panel. The first one is on the issue of joint and several liability. I just want to find out from the panel as to what will be the CCMA's approach to such dispute. And the second one is on the issue of justifiable reasons for certain employers who can be actually exempted on the issue of the TES. To say, I just would like the panel to actually elaborate on that.
Thank you very much, Makata. Makata saw we didn't respond to this, we didn't read his tweet now, he decided to call. Cameron, the issues raised by Makata, for instance, I had a case for a sister of mine who was employed through a labour broker, and we wanted to take action against both the labour broker and the person who had contracted her, the labour broker. But we couldn't because we were told the lawyer who was handling our case had a conflict of interest.
He had a conflict of interest?
He was also the lawyer of the company that was contracting out.
I think it's important to understand that certain type of acts or conducts that happened before the amendment will be treated differently compared to after the amendments, because the provisions are different. For example, the issue of joint and several liability. If there's a violation of a collective agreement, for example, or a wage act or anything like that, that has been done, then yes, you can institute a joint and several liability against the TES and against the client. That's how far that applies. What I didn't understand from the question is the justifiable reason on which part. Because justifiable reason
I think what he's talking about, I read somewhere in my research that this these amendments are going to be detrimental for small business. I think that's what he means. There could be a justifiable reason why we cannot keep somebody on when we don't have a job for him.
Yeah, I'm not sure about...
I don't know whether... Let's ask Andrew. Andrew seems to be...
No, I think the thing about small businesses is that you tend to deal with a lot of employees like on a short-term basis. So if you need probably, say, 4 or 5 employees, but then you need some people to help you now and again on a part-time basis. And small businesses tend not to employ part-time workers because they're scared of what's going to happen to them. Are these people going to be taxed? Must they register the people? Must they do this? Must they do that? And there's a lot of inhibitions to employing people beyond what you can afford.
Well, let's go to a break. I know somebody was burning to answer to get involved there. If you'd like to join us, you can still call us on 011 714 5497 or 5498 or tweet us at Rights Recourse. We'll be back right after this.
Should marijuana be legalized in South Africa or not?
The legalization of dagga is a no to our country. Look at the rate of rape in our country because of people that
But you can't say dagga makes people
that
get
are under
raped.
the influence of dagga.
When a young man comes to you and says, I'm having a problem with dagga, do you send him to jail?
We don't send them to
Then you already concede that you agree that prohibition is not the answer, Mr.
because
Panda.
our aim is to help them.
As is ours.
It is you helping them by giving them dagga. How are you going to control this? Just give me a chance. Because if you cannot control it now, as the CYP of South Africa, we say no to the legalization of dagga.
Do you think?
No matter what you study, no matter what you tell me,
Do you
I say
think?
No.
Watch Newsroom with me, Eben Janssen, weekdays at 9 a.m. on the SABC News channel.
Welcome back to Rights and Recourse as we take you to a call from Libua in the Free State. Libua, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir.
Yes. What's your question?
I've been dismissed at SASA. I was working at SASA on the contract.
Yes, go ahead.
So I want to know, is this a clear dismissal? Because they knew exactly that I don't have a senior certificate, but I only have a subject certificate.
Okay, thank you very much. I think this is an issue of she's been dismissed by SASA. She's working for SASA as a part-time worker. And now, apparently she doesn't have a senior certificate. I think they asked her to give, if you want a permanent job, then you'll have to bring a certificate, senior certificate, yes. That's a matric.
She was dismissed because she didn't produce that.
She didn't produce that.
What is the question then?
The question is, what should she do? She does have subjects she has done, but she doesn't have a certificate.
This is what must be done, because I don't think any one of our members of my panel can answer the question and say it's fair or unfair, because the employer has something to say to it. There's always two sides to the story. What she needs to do is to refer the dispute and say, I have been terminated. Reasons, because I did not have this. So you have to categorize also the type of dismissal it is. So the employer will have to show that. So only then at that stage can you make a determination. But I don't think we can say what the requirement was, what was the reason, what is the version of the employer, and balance that with what she says and come to a conclusion. A proper referral with a commissioner appointed, evidence standard, that determination will be made at the bargaining council.
Quickly, gentlemen, I want to go to Cameron to talk to us about the roadshow, but yes, what I want is to hear from you as a lawyer how these acts are going to make your job easy and also bring relief to those people who are knocking at your door.
Well, I think the thing is that hopefully the labour courts are going to be that much more accessible, and people can refer different kinds of cases to the CCMA, like discrimination and the like, because the CCMA has now got the right to hear discrimination issues and many different kinds of things like strikes and the like, and they're going to be a lot more busy. the labour court's already busy, but the labour court takes a long time. So people must understand that if they come to knocking on my door, their case is only going to be heard in a year's time. Whereas the CCMA can probably do it in three months or even less. Yeah. And they might even conciliate and solve the matter, you know, within a month.
I've never seen a lawyer pushing work away from them. Paul?
I think you, in fact, one of the most important features of labour law has been the way in which it has tried to downplay the role of lawyers. Lawyers can only appear in the CCMA in relatively limited circumstances, and that has been very successful. It has allowed disputes to be handled much quicker than they would be in the courts. So yes, as both speakers have said, there's been an opening up of the jurisdiction of the CCMA cases, like equal pay cases, which have been able to be brought in the past, but there have been very few will now go there. People can bring claims if they're dismissed also for unpaid wages. And I think combined with the changes to the labour court procedures, it's going to mean disputes will be resolved quicker, and that's good for everybody.
Cameron, the question that is in my mind is the promulgations were the amendments were promulgated last year in August. Can cases be looked at retrospectively?
No. There are certain transitional periods that have been set. For example, when it comes to the enforcement of the awards that cannot go to the Labour Court anymore is only effective from the 1st of January 2015. But those that were issued prior to that date will still have to follow the same process that used to be followed.
In the same breath, I just wanted you to talk to us about the road shows. Are you trying to convince employers?
Yeah. The name of your show actually nicely captures what we are doing. An employee and employers can never institute any proceedings against anybody in an institution like the CCMA unless they know what their rights are. That's part one. Part two.
Is it about the role of the CCMA to teach people their rights?
Yes, to know their rights and know exactly where they stand in law, because it is their constitutional right, because they are entitled to fair labor practices. The second part, which is the second part of your show, which is recourse, is that once now that you know this is your right, what recourse or remedy is available to you and where to go. And that brochure we do nationwide. And we've already started with that, and tomorrow we are in Cape Town to teach people about the amendments, the Employment Equity, the Labour Relations Act, the Basic Conditions of Employment.
So anybody can go to this?
Everybody is invited to come and attend. It is a free-for-all, and it's free of charge, by the way. No one's going to be costed for these road shows.
Well, gentlemen, it looks like we will have to have another round of discussion around this very issue. There are many issues which we have not gotten to, but time was actually not on our side. This has been Rights and Recourse. This program is repeated at 10 tonight and 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.
Coming to you live from our Auckland Park studios in Johannesburg, South Africa. Welcome to AM News on SABC News. We're on DSTV channel 404. Thank you so much for joining us this morning. We'll be taking you through all the developing stories, all the leading stories in South Africa, in the continent of Africa and the rest of the world. The power utility has attributed the current wave of load shedding to what it has described as unforeseen technical problems at current power stations. Eskom has warned that there is a risk of a total blackout